The court case I reviewed was Gill versus Tamalpais Union High School District in California. The case was heard in the California Court of Appeals in 2008 and involved providing a safe environment and equipment and medical response. The incident involved a 15-year-old sophomore girl, her last name was Gill, at one of the high schools named Redwood. She was trying to make the JV basketball team and thought by attending open gyms prior to the season it would help her chances of making the team. She had attended the off-season preseason open gyms for the past 5 weeks that were inside the school gymnasium. But on this occasion, they had gone outside. The outside court had backboards attached to 2 metal poles. The district had instructed all those using the equipment to put padding around the poles. This included the volleyball, PE, and anyone else in the community that was utilizing the teams. On that day, the pads were not put on the poles. Under direct supervision by the coach, the girls were instructed to do full court layup drills. On the 3rd or 4th time, Gill went up for a layup and was temporarily blinded by the sun. As she came back down, she hit her face on the pole, and she suffered a very significant cut below her eye that was, quote, bleeding profusely. The coach did not see the incident directly, but was informed as the other girls helped Gill to her feet and took her to the coach. The coach told Gill to go see the trainer inside the high school. When she arrived in the training room, Gill was instructed to hop up on one of the wooden counters because the athletic tables were being used by other athletes. The trainer left the room, and as she did, Gill blacked out and fell face first onto the floor from the counter and knocked her front tooth out and broke 2 others. The trainer came back in and called the school nurse, who immediately called 911. Gill was taken to the hospital. She missed 10 days of school. She stayed the night in the hospital. She missed 10 days of school and could not eat solid food for 6 months. She claimed that she suffered migraines and developed a fear of dentists. To make matters worse, she was actually cut from the team in a, quote, humiliating fashion. Gill filed for complaint seeking damages from the school district, but not from the medical facility that supplied the trainer directly. There was 2 causes of action filed, one of general negligence, which was actually dismissed by the trial court, and the second, which was heard, that was considered on the premises of liability that the school had maintained a dangerous condition of public property. The school filed a cross complaint against the medical facility that provided the trainer. The district's defense was that that basketball is an inherently dangerous sport. They believed that the facilities did not directly lead to the injury. The medical facility and the school also said that the coach and trainer both provided adequate care for Gill. Gill and her parents claimed that the school inadequately supervised the open gym session, did not provide a safe playing environment and safe equipment. The school also failed to exercise reasonable care in the training room, and the school did not have adequate emergency medical response plan in place. As a result, the jury awarded Gill $477,000, which to be paid by the school district, but it was reduced to the amount of $336,932, which was roughly $500,000 that the medical facility would have to pay. The school district and the medical facility both appealed the verdict, but it was upheld in the appellate court. The court's remarks about the school claiming that basketball is an inherently dangerous sport, they believed that the outside courts designed for the goals were unsafe. Otherwise, if not, then the school district would have had the same setup inside the gym. But more importantly, if they truly believed that the setup wasn't dangerous, they wouldn't have purchased padding and told everyone that those pads need to be utilized at all times. The high school claimed on their appeal that no dangerous history also was shown involving the equipment. To this, the court basically said the school thinks that in order to be liable, there has to be history. So basically, how many students would need to be injured before they were liable? The medical facility tried to say that the trainer responded with adequate care. The judge stated that both the coach and trainer, who were both CPR certified, should have known and recognized the fact that the young lady could have suffered a severe head injury and concussion, which could cause lowering of her blood pressure and possibly loss of consciousness, which happened. As far as what the implications from this case are, I'd have to say that once a district knows that the equipment is dangerous, they should find a way to replace it, not just a temporary fix by adding padding. If it is inherently dangerous and they know this, that is their responsibility to get it fixed. Just as the jury found that the plaintiff of the district knew that the equipment was dangerous and the two staff members did not act correctly in the accident directly afterwards, I would, as an athletic director, I would make sure that I would do everything possible to keep all my staff members up to date on their CPR certification, emphasize the risk of a concussion or a head injury. That way, if something happened, the parties involved would know not to leave a child unattended on a 4-foot countertop. If there is a chance of injury and the district knows it, then the implications from this case are very simple. Fix the equipment. If it's broke, if it's dangerous, it should not be utilized.